My name is Mark Hughes. I'm co-chair of the Ethics Committee here at the hospital. And this Ethics for Lunch, some of you are familiar faces. For those that are new to us, is a monthly series co-sponsored by both the Hospital Ethics Committee and the Berman Institute of Bioethics. On your handout, there's more information about both the Ethics Committee and Berman and the people that are involved in that. So this is an opportunity for us to interact with you in the community, the hospital community, the larger Baltimore community, about issues that pertain to medical care, health care of patients here at the hospital, pressing ethical issues that we're encountering in society, and so on. And today we have such an example. To remind you, even if you're not going for continuing education, it's helpful for us, we always have a great turnout at Ethics for Lunch, but it's helpful for us if you still log in to the continuing education website through your smartphone and plug in the code that's on these handouts in order to register your attendance. If you do need it for continuing education credits, that is noted on their website, and you can access that in the future. But even if you don't need the credits, it's helpful for us to just know how many people are coming to these sessions, so I encourage you to do that. So today we're going to be talking about ethical challenges in supporting young adults with disabilities and their families. Michelle Melicosta is a pediatric hospitalist in the Kennedy Krieger Institute, so we've invited folks from KKI to give their perspective on these cases where it's children transitioning into adulthood and the issues that need to be thought about as they achieve adulthood, especially in relation to their parents, the rest of their family, and the healthcare clinicians who will be caring for them in the future. Dr. Melicosta is, as I said, a pediatric hospitalist. She's also co-chair of the Ethics Committee at Kennedy Krieger. She was a former chair of the Ethics Committee in the Gallup Indian Medical Center, and then had a stint in Germany where she was helping the U.S. Army stationed there taking care of children with healthcare needs. So she's going to introduce the rest of the panel, and I appreciate all of you coming today.
Thank you. So we're really excited to be here. This is actually my first time at Ethics for Lunch, which I realize is probably I should come to watch first, so I knew what I was doing. I'm really happy to have the rest of my panel with me. Dr. Ritu Goel, who is from Kennedy's Department of Child and Adolescent Psychiatry. Maureen Van Stone, who's the director of HEAL. Project HEAL. I'm not part of it. And then Karen and Jim McIntyre, who's our mystery guest, because I did not get his name on the slide, I apologize, who are parents of a former Kennedy client and are here to give their perspective on issues of transition, and Patricia Shepley, who's the senior director of our social work department. Dr. Goel is going to present our case for today.
Thank you, Dr. Melicosta, for the introduction. So we're going to talk about this former patient of mine, which we have one of the ethical challenges, which I would like to present to you. Can you hear me? Yeah. Okay. So this is a male patient who just turned 18 years old. He had diagnosis of high-functioning autism spectrum disorder and bipolar disorder. He was generally stable on medication for the past year, but he had regularly expressed ambivalence about taking medications. And prior to turning 18, his parents reported that he sometimes skipped his medications, which caused an increase in emotional lability and poor judgment. Over his teen years, there were significant challenges establishing an effective medication regimen and also compliance with medication, which led to 2 admissions due to manic episodes, placing him at risk to harm to self and others. His clinicians have found his parents to be central to his treatment. They have transported him to all his appointments and provided regular information to the treatment team regarding his functioning and medication compliance. as he approached his 18th birthday, his parents expressed concern that once he turns 18, he would either become inconsistent with medications or may even stop it altogether. He plans to remain living with his parents for the near future. After his 18th birthday, he stated to the treatment team that he did not want to involve his parents in the treatment care, and he did not want to share any of his medical information with them. He refused to sign consent to release information to them and also advance directive for health care. The psychiatrist, which was myself, determined that he had capacity to make decisions for his treatment as he was stable in his psychiatric condition and he was taking medication for over 1 year consistently. Now, however, his parents strongly disagreed with this determination as they believed that he was having this capacity because he was taking medication consistently, which they were worried that he will not take once his parents will not be involved in his care. Now, I'm going to briefly take you through the criteria for assessment of capacity to make a decision. And this capacity assessment is actually, it varies from one decision to another decision. So what I mean is that having capacity to make decision about one aspect doesn't mean they have capacity to make decision about the other aspect. And this can change over the period of time, so it is not permanent. And it is different than the legal term, which is the competency, which my colleague will talk in a little bit. So there are essentially 4 major criteria when we determine the capacity, that whether the client understands the relevant information. And the information that we talk about is essentially, in this particular case, is what is the kind of condition or the illness or mental illness, in this case, we are talking about. And nature of proposed treatment by the physician is benefits and risks, and any alternative treatment that is being proposed by the physician, and their benefits and risks, and also of not having such treatments in future. What would be their benefits and risk. The following one is appreciate the situation and its consequences. And that involves that, do they believe if they have that illness or condition? Do they believe that they need treatment? What do they believe will happen if they do not have the treatment? And what do they think why the physician has recommended this particular treatment or any treatment to them? The following is reason about treatment options. And this actually focuses on not just what treatment decision or what decision the patient or the client has come to, but at the process, how that person has reached that outcome. Because our clients or our patients have the right to make some unreasonable decisions. But how they reach that decision is what matters the most. And the last is communicate his choice. Now, can this client communicate his choice? Whatever it is, whether to continue or not continue treatment in this particular case, consistently, which means if they fluctuate every now and then about their choice, that is considered they may not have capacity to make decisions. And now I'll give it to Maureen.
Thank you. So I am a licensed attorney in Maryland, and I represent our patients, both children and adolescents and young adults at Kennedy Krieger Institute. And what I sort of want the audience to start thinking about is adult guardianship and less restrictive alternatives that are available in Maryland. So guardianship is in fact a legal proceeding in which the petitioner, who is usually a family member, it could be the mother or father or an adult sibling or a close friend, will ask the circuit court in the jurisdiction where the individual lives to find that a person is unable to manage his or her own affairs effectively because of a disability. The court will then appoint someone to act for that person and make decisions affecting his person, his property, or both. One person can serve as both the guardian of the person and the guardian of the property, or different people can assume each role. So for example, the mother may want to make decisions for this patient in terms of his person, and the father may say, I want to deal with the financial aspects of it, and I will be the guardian of his property.
In emergency situations or when an individual has no family member or friend to serve as a guardian, the circuit court may appoint a public guardian, and that could be a public official or a publicly funded organization. In terms of guardianship of the person, that individual will be making decisions about the person's medical care, which would include psychiatric treatment, housing, food, clothing, other decisions about activities of daily living. In terms of guardianship of property, that individual will be making decisions about the person's money, their income, any property, stocks, bonds, other financial matters, which may include inheritance or public benefits. And essentially, the effect of going through the court to create a guardianship of a person means that that adult with a disability may no longer have the authority to make decisions about his personal life or property, because that authority has been delegated to a guardian through the courts. And really what the court is going to be looking at in these cases is that the petitioner of the court has explored other less restrictive alternatives and determined that this is the only viable alternative in this situation. I do, however, want folks to realize that there are alternatives to guardianship, and this is what we want families to explore first. One, because they may be more appropriate for the individual. Two, because they're less expensive. Guardianship proceedings in our state can be very expensive. Families often don't know that they are responsible for the court fees for filing the petition for guardianship. They are responsible for their own attorney fees as the petitioner of the guardianship. And they are also responsible for the fees associated with the attorney representing the alleged disabled person in the matter. And many families are unaware of those significant expenses. Additionally, anytime the guardianship order needs to be modified or changed, you have to go through the courts in order to be able to do that. And alternatives to guardianship provide much more flexibility because they are not involving the courts, and in some cases they may not involve a lawyer at all. So a few alternatives to guardianship that I wanted to highlight when we're talking about guardianship of the person include family guidance. That's simply, as Trish will explain, some of the education and materials and resources that social workers, case managers, and others can share with families to help them start thinking about these complex issues. Adult assistance services. There are a number of services through the Developmental Disabilities Administration where adult individuals with disabilities may access case management services, in-home supports, respite care, utility assistance, etc. There are a number of public housing services and programs that may be available to the individual. And then, of course, there are the advanced healthcare directives, which some of you may be familiar with. And this is a statement, it can be written or oral, of a person's wishes about their future healthcare. And again, it's important to note that the advanced directive is that individual's wishes. That individual can appoint a healthcare agent and can provide healthcare instructions in terms of the type of treatment or care they hope to receive in the future. In Maryland, we have an advanced directive for mental health service, and that is the appointment of a healthcare agent to ensure that the individual receives specified mental health services. It can include the identification of mental health professionals, programs, or facility that the declarant prefers. So the individual may actually state in their advanced directive for mental health services certain treatment facilities, certain types of medications, certain types of physicians with whom they may want to work. Again, a statement regarding the medications. Many individuals can articulate medications that have had adverse side effects for them, or medications where they have had success in the past, and those are important things to include in the advanced directive. And then lastly, instructions regarding the notification of third parties and the release of information. So who can be sharing information about this particular patient when they're in a mental health crisis. And then lastly, what we consider is sort of the least restrictive option is a surrogate decision maker. So someone who acts for the person and can make medical decisions for the person who is unable to make medical decisions for himself. And the law in Maryland, under Maryland Healthcare Decisions Act, specifies a list in priority order. In terms of alternatives to guardianship of property, an individual may appoint their mother or father as their representative payee. And so that person could receive the benefits, the public benefits for the individual on their behalf and use them to help them with paying for their expenses associated with living independently. There's also an option of a durable power of attorney, which will grant authority to a third party, that is the person that is designated as the agent, to act in place of the individual. Another less restrictive alternative to guardianship of property is just having a joint bank account. So the alleged disabled person would have a joint bank account with their mother or father to help them manage their funds. And then lastly, trust. And there are a number of special needs trusts and other accounts, including the ABLE account that will be effective in Maryland next month, that could be alternatives to the guardianship of property.
No, come on up. Just leave that there for now. That's fine.
Good afternoon. We are the McIntyres, and our daughter is 23 years old with an intellectual disability, or may I say an intellectual ability. One of the biggest fears for parents with any disability is looming adulthood and all that it encounters. What happens when we are no longer here for our children or adults? We don't want to think about that, right? Finances. Who can live on $700 a month? Arranging trusts, guardianship, finding caregivers, and then finding caregivers again. Housing, roommates, healthcare, social life, oh yeah, happiness. Realizing all of this, we as a family decided our focus for Alex's transition was to be life-bound and not diploma-bound.
Good afternoon, everybody. I'm Jim McIntyre, and when Karen said she was coming to speak, I said, can I come? Because I always like to be involved in groups like this. So if there is one thing that I can say that could help you to pass along to teachers or to parents, that's why I'm here. I just jotted down a couple things this morning in regard to our journey, and it is quite a journey. The first thing is the partnership that Karen and I have. We often say to each other, we couldn't imagine doing it alone, and we know and understand there are many single parents that do this, and it just, we just can't imagine the challenge. We've always depended on each other tremendously to get to where we are today, and we still have a lot of work to do going forward. As Karen said, our daughter's 23 years old, and the journey to get to the 21, when it's often talked about walking off the cliff, it really is, with not only the support that you have throughout all those years, but the finances as well. When I talk about the partnership, it really does come down very quickly when you have your child and you recognize that she or he has challenges. It's the decision to fight or flight. And I would love to, haven't ever taken the time to look at research of how many divorces there are with parents that have a child with disability. Secondly is the IEP process. How many of you are involved in IEPs? Okay. The IEP was always quite interesting for me. I often would walk out of an IEP with Karen and say, you know, I feel so deflated, and it seemed to be so negative. And, you know, there just didn't seem to be a lot of solution to what we were talking about. And the point to parents that we always talk to is that you've got to go into an IEP prepared. And if you're not prepared for that IEP, it's literally a waste of time. And as I said, it can be quite intimidating sitting in front of a group of people that know their information, and if you're not prepared, you can be beat down very quickly, and that's what it comes down to. You can feel that beat down feeling. The evolution of education with our daughter, we're from Howard County, so we started the education process with our local elementary school, kindergarten. We quickly realized that the gap had widened, and we were told that that would take place, but it came very quickly. So we began to look for other alternatives outside of Howard County as to specialized education. And that was a battle in itself. We worked for several years to convince the public school system that this was not the place. And we ended up here at Kennedy Krieger across the street. We were at Kennedy Krieger, I believe it was 5th grade or so, traveled through middle school, transitioned into Kennedy Krieger High School, and then we quickly realized that that was not the place for Alex, that we had to find a better match, and we ended up at St. Elizabeth's High School, and that's where she went to high school until she was 20 years old, and then there was a pilot program that just started out in Howard County with internships, and that's what we did in the last year. And that led us into some good experiences, but didn't connect us with our overall goal, which was a job. In regard to at 21, some decisions that need to be made that we realized very quickly was that there's funding there, not much, but then you need to make a decision. Do you go to a typical ARC situation, or do you look at what is called a self-direction program? We decided that we would go to the self-direction program and manage it ourselves, which was scary in itself, but that has worked out very well. We have some advantages that many parents don't have. One being, as I mentioned, us together fighting this day to day. And then secondly, finances. That obviously is a big advantage. But the overall transition goal for us was finding a purpose for our daughter. And you've heard this many times too, is the biggest fear for parents is your child not sitting in your living room. And that continues to be our fear, I'm telling you. We're lucky in the sense that we prepared our daughter way back at middle school over here, because we made a big decision then, diploma bound or employment bound. And we decided employment bound. Learning algebra to us for our daughter wasn't as important as preparing her for a job. And that was a tough decision to go through and realize the reality of that. It continues to be an everyday struggle. As I said, we're lucky we have our own business, so our daughter is able to go and work in our business 3-4 times a week. The challenge is finding that job coach that can go with her, and knowing that just as we found that teachers change all the time, you find a teacher that was very positive and productive for your child, and then all of a sudden they're gone. And that's the same thing with a job coach, that you just never know when that's going to end. And that continues to be the challenge as well. So anyway, that's our story. If I could, or we could provide any more information to you as advocates and providers to parents, we would love to be involved and give you a whole lot more information. I hope this was helpful to you. Thank you.
How many of you are parents of adult children? So you know that transition to growing into a parent of an adult child without thinking about IEPs and transition with disabilities or coping with mental health issues is challenging enough. I used to call my new adults, who are now 28 and 30, my new adults, but I was also a new parent of an adult. So it takes time for all of us to go through those transitions. What I'd like to add today, because I think that Karen and Jim have really well articulated many of the things they've had to think about, is that in offering some of the family piece of this as providers, we have the opportunity to both look at whatever resources are available that can be shared, and in preparing the family, certainly just even understanding all that Maureen shared with us, I think can be a very big challenge. And understanding how does my particular child fit within that, that list of alternatives, and what do I need to think about? So I know that there's a lot of social workers in our audience today, because I see a lot of familiar colleagues, and this is something that hopefully we would be checking into, or anyone really providing care would be checking into. Are you even thinking about these transitions, hopefully starting around 14? But as it gets closer to adulthood, perhaps we then find that some people that are caring for the patients that we receive are surprised, because the school is still talking with them about the IEP. They've not been asked to do anything different. And you know, their child then comes and presents for care, and they're 18. But you know, some families will get a little confused about that. They'll think they have guardianship. So there's a number of different factors that can be a challenge for a family, just in terms of their transition into adult care. So I would say, just in terms of giving a quick list of the things that I would think about, would be if we found that, for example, our case study, where the parents are very concerned because they felt that their child was doing well because of the care and the support that they've given. Working with that family a little earlier on, before the transition age, we would be thinking about, well, we don't really know whether or not your child is going to qualify based on capacity for any of the alternatives. Perhaps it would be really clear, but perhaps not. And I think it's kind of the on-the-line questions that I've seen over the years become complicated in family dynamics. So what are we going to do to try to educate both family and nearing adult child to be ready for that, and to start looking at all the aspects of how they get support? And if they were to make all of those decisions, how would they make all of those decisions? And what access do they have to resources to support? You mentioned the turnover of staffing, and that's for many of you who are already involved in helping families that have staffing. That's just amazing. I work with one gentleman who, over the course of seeing him, he's very stable now. I see him monthly. I noted that in 6 notes, he told me that he was going to have a new aide. This one quit or just resigned. So that's happening a lot. And if maybe the mental health concern involved is something that causes the person to have difficulty with transitions, that's something to think about right there. How involved are they in interviewing and making selections? So there's many aspects of this that can go into both practical day-to-day care, and in thinking about providing the psychoeducation to both the patient and to the family about, as Dr. Goel mentioned, what the risks and benefits are of the medications, but also of thinking about what's happened in the past, what situations and what supports did it take. So the last time this individual became manic and had difficulty, what sort of bumps did the family encounter? Because if this individual should choose not to allow his family to be involved in care, then that's something that he's going to have to choose to deal with on his own. And would there be other agencies involved if it became an out-of-control situation? And for patients who have had the support, living support how small or large they are, that may be a new piece of information for them. Even if mom and dad did show up, if they were not pre-authorized to help, then we would have to wait until that person could be deemed completely incapacitated before we go into that stair step of surrogates that would be allowed. So there's a lot of gray areas in which it can be, I think, very challenging for both parents and for emerging or new adults to digest and to think through, because you're really thinking about the what-ifs of life.
Thank you guys very much. So there's just some references, I'm going to leave them up there as people start thinking about questions. I think there's sort of a lot of different perspectives represented on the panel that all sort of speak to the case that we had. Can I ask a clarifying question? So my understanding for capacity is that it's context specific, correct? So you could have capacity to make a medical decision, but not the capacity to make a financial decision.
That is correct.
That's correct. And then is it, and I guess in this case, what you wonder is it also context specific in terms of, could this person be judged to have capacity while he's taking his medications, but if you examine him off his medications, he might not?
It can change.
It can
Exactly.
change, exactly, okay.
So yes, the capacity is not permanent, it can change, and that's what it is. At that point in time, when the person is stable and is able to understand the situation and weigh the risk and benefits, come to a decision and has been able to inform his rationale for coming to that particular decision and is able to communicate it consistently, is deemed to have capacity at that moment. However, it can change due to a number of reasons. Due to if he stopped taking medication, or even if he's on medications and become manic or has delusions or any other mental health or neurological conditions can interfere in him having the capacity on another occasion that we examine him.
Thank you. So before I go on, does anyone have any questions? Oh, sorry, yes.
It's good. It's all meant.
I just wanted to add one confusing point that I think the McIntyres illustrated really well is that for a child with a disability who is receiving special education and related services under the Individuals with Disabilities Education Act, who continues to receive services after their 18th birthday, those parents or legal guardians retain educational decision-making authority. In contrast, under the Maryland Healthcare Decisions Act, when that individual turns 18, that person is deemed to be competent to make their own healthcare decisions unless determined to be incapable via the certification of incapacity or the circuit court in the jurisdiction where they live determining that they're incapable. So that's sometimes a really confusing point for families who in one context can make those day-to-day educational decisions. They can be invited to team meetings, they can consent to the provision of services, but when they bring them to the clinical setting, if they're coming to Kennedy Krieger or Hopkins, and the court has not appointed a guardian or they have not been determined to be incapable of making decisions, then it's up to the actual individual with the disability to determine whether or not he or she wants to include their parents in that decision. And I think in the McIntyre's case, they're fortunate because Alex is verbal and she can communicate her wants and needs, and she can communicate to her clinicians that she wants to include them in the process or bring them into a clinical session or an appointment. But in some of our patients' situations, that's not possible, and it becomes really a difficult situation for the clinical providers.
Thank you. I want to open it up for any questions or comments. Yeah, go ahead. Oh, I think Pete has a.
Along the lines of what you just spoke about, in a therapy situation, if you have a young adult who does not wish to participate in therapy, the adults choose to bring them and they want to bring them, but the young adult, or the parents choose to bring them and want them to participate, but the young adult does not want to
is this a child so are we talking about a child who is still a minor and parents?
You know, over 18 and situations where, you know, they've had therapy on and off, they're not interested, they don't want to participate, their parents still want them to take therapy services.
Right. And does this person has capacity to, or who's doing the consent in this case?
Well, I'm thinking, I guess, more not of a specific case, but some general.
Yeah, so again, it depends on who, does this person has capacity to make decisions? Is this person the one who is signing his treatment consent? If he or she is signing the treatment consent, then client has right to make unreasonable choices. They may not be right, but this parent and we as provider think, but if he has capacity to make that decision and has a reason, a process by which he came to that decision, and he may have very unreasonable choice. In that case, of course, you can just work with the family and see what are the barriers that this person doesn't want to attend therapy. You can work through that. But in terms of the rights, then parents don't really have the rights to push for it.
My question is, can you say more about the right to make unreasonable choices and what those unreasonable choices are and how they're determined unreasonable?
Very good question. And that really does lead to the challenges or the complications of capacity making assessment. And what it means is that once a thorough assessment has been taken place about whether this individual has understood the information that is presented by, and we are talking strictly here right now about the medical decision making. In that context, what the physician has or the therapist has presented the information about the illness or the condition or the treatment. Has this person understood that? Then has that person understood the risk and benefits, and does this person believe that they have that condition, that they have understood what are going to be the risk and benefits of having that proposed treatment or not having that proposed treatment, and what would be the consequences of having that treatment and not having that treatment. Now, when this person has gone through all those steps during the assessment, and physician has found enough evidence that this person has understood all that condition, and I will give you an example of that in a little bit. And then, even despite that, if this person chooses not to follow through the treatment recommendation, and they are not necessarily life-threatening, where it becomes a completely different scenario where the capacity will be overruled, then it can be given a choice. Of course, it really depends on what treatment, what kind of consequences of not having that treatment will be. For example, if somebody has anxiety disorder, and I'm talking from the perspective of a psychiatrist, and comes to my clinic, has turned 18, and parents want this person to have treatment, medication, and therapy for that matter, and this person says, I am managing okay, yeah, I have some anxiety here and there, yeah, I don't want to socialize, I don't like to participate in those things, but what if I'm doing, it's not bothering me, I don't want to continue. But this person has understood what his illness is. He or she understands that he has this anxiety disorder, she understands what are the benefit and the risk of having treatment versus not having treatment. And they come to the decision that they don't want to have medication on it, and they don't want to come to therapy. I mean, they can still be deemed to have capacity because they have met all the 4 components that they are able to communicate, all the capacity assessment, but it may still be an unreasonable decision.
I think that's a really good question. The first article up there, if people are interested in that line of questioning, it talks about that, I don't think I've ever asked a psychiatrist for a consult to determine capacity on a patient who is agreeing with me, right? I mean, because I think as physicians, we say, well, this is my recommendation, and if you're agreeing with me, I'm sane, right? And I know what I'm doing, and I have capacity. So, so we sort of, there's this assumption that that's a reasonable course of treatment, which may or may not be a valid assumption. And so how far out does the patient get from my sort of thoughts about what's reasonable before I then think, oh, maybe you don't have capacity, and I'm gonna, you know, maybe you're not understanding, maybe, you know, and that's when I ask for a consult. So Howe's article talks a lot about introspection for ourselves as providers about what's our ethical role in when we ask someone to make that determination. And it certainly comes up a lot with teenagers, you know, who want to refuse painful and perhaps not ultimately successful treatments against the wishes of their parents, and that's one that we struggle with. I think that's a great question. Can I ask you guys, have you and Alex ever disagreed about something that you wanted her to do medically? As a personal question, only answer if you want.
No, Alex is very compliant.
She's,
Yeah.
Okay.
So we count our blessings.
Yes.
Other questions?
Maureen, I think you made a really good point. Maureen made a really good point in starting at age 14 to get started early talking about these issues. When you start talking at 17 and a half, when you have 6 months to go, it can be a longer process. And starting at 14, you can really explore those barriers to or feelings around receiving and seeking treatment and what to do in a situation so that they can have the autonomy over their own decisions. And 14 is a good age to start, I think, from both personal and from social perspective.
And just so folks know, in Maryland, if a student with a disability receives services through an IEP, the IEP team must legally start discussing transition services beginning in the first IEP to be in effect when they hit their 14th birthday. So federal law, for those of you that may have come from another state, requires transition planning to begin at age 16, but in Maryland we provide greater protections to students with disabilities and require it starting at the age of 14. And I think it's good because it gives parents time to really go through some of these complex processes and discussions and figure out how they're going to navigate educationally, medically, employment-wise, adult service systems. It takes a lot of time to figure out how to navigate through an entitlement process, which the child has through the local school system, to an eligibility process, which occurs once they reach the age of majority.
One other issue that I see come up too that touches on this is that, not exactly the issue of hidden disability, but the idea that there are people who may present as having capacity more than they really do. And during my years with the Army, one of the papers we did looked at people who had TBI, soldiers, these are adults obviously who had TBIs, who on neuropsych testing had intact memory, intact cognition, but very poor executive function and very poor judgment. And so how do you take someone who in an interview is very appropriate cognitively and is, you know, able to sort of reason things out very nicely, but in life is continually making poor judgments, and so how do you help them? And I think another area we're seeing that is some anxiety and bipolar and depressive disorders, where we're starting to realize that there may be more, you know, we've always kind of differentiated those from affective disorders versus thought process disorders, that there may be some disordered thought that in fact impairs ability to make decisions more than we're aware. I think Hope has done a couple of papers on that that are worth, I didn't include them, but my list is getting long, but are worth looking at if you're interested in that, that sometimes it isn't always obvious who we should be asking for that kind of consult on. Other questions?
So since capacity is just with regard to medical decisions, I'm particularly interested in something like housing or shelter. Could a person have the ability to make medical decisions, but there's concerns that they couldn't really manage in their own home? And I'd also be interested in how the McIntyres thought about Alex, and was she going to be independent or still live at home? And could you seek guardianship just for, if it's guardian of the person, just for things like housing and, food and so on, but not for medical decisions?
So no. And that's why you'd explore the less restrictive alternatives in those cases, right? So the person could potentially execute an advance directive for mental health, so that when they needed it, their parents as agents could help them make those decisions based on what their wishes are. But to deal with issues like housing or finances, they could execute a durable power of attorney, they could be the representative payee if they're accessing supplemental security income through the Social Security Administration, they could have them access services, housing services and programs through the Developmental Disabilities Administration and help them navigate that way. But when you're assuming guardianship of person, you're essentially taking away that person's autonomy. And that's why it's considered so restrictive, and we want to encourage the exploration of other options.
We've begun to have more intense conversations, if you will, about Alex's future of living. And for us, it really, I guess the best way to describe it is trust of Alex going and living elsewhere, and we know that we need to get over that. We've begun to take steps, small steps, in regard to Alex has been going to a camp over the summer for several weeks, and this upcoming year we've been looking at a program down in Jacksonville, Florida, where it's a 4-week program, and beginning to move in that direction. I think the trust for us goes back to myself and my background when I first came out of school, and I went to school here at Hopkins and got a master's degree and worked in the field for just a small amount of time before I decided to do other things. But so I kind of know some of the background of the alternative living units and that sort of thing. And I think that's a stumbling block for me and Karen that, again, we just need to overcome and find the right place. So we're trying to get there, but we just haven't, but we know that we need to. So again, just trying to find those stepping stones to get Alex and us to that comfort zone of her future.
Also, just the employment has taken a bit of time, so we have a goal in mind for a number of years, and again, like I said, what happens to us, and Alex is on her own. So we want her to live independently, and it's a transition. It's a huge transition as parents, like Jim said, for us as well as her. So.
Yeah, I think the battle is also, our future to Alex's future. We're kind of splitting time here and in Florida with living, and the struggle is that, as Karen said, we've concentrated on the employment and trying to get Alex stable, and she is here with employment. But then when we go down to Florida for a period of time, there's the struggle of finding that job opportunity with a job coach, and we're not down there enough to make that investment. So there's kind of that, and where's the commitment? Here in Maryland? Is it in Florida? So we have those balls going at the time. But we've concentrated on the employment piece of it, and now trying to travel into what is the living situation coupled with the job opportunity.
of foster care, so they haven't been adopted. Kind of, what does that decision-making discussions look like?
So it actually depends. In some cases, when they're exiting the system, at what age they're aging out of the system, and what level of support they had in the system, and whether or not they can live independently, and when other state agencies may step in. So for foster care children in the state of Maryland, there are additional protections through other state agencies that may kick into play, and they are entitled to additional benefits for a longer period of time. Presumably, sort of the philosophy behind that is that they don't have, like the support that Alex has had to appropriately plan for transition. Even when you have that support, it takes a long time. But a number of kids, as you all know, who are in the foster care system and who are adolescents are bounced from home to home, from school system to school system, from medical provider to medical provider. And those adolescent years are very, very challenging for a foster care child who has a disability. And so we provide additional protections to them for longer periods of time. If they're in the capital region, there are a lot more resources available. If it's a foster child with a disability on the Eastern Shore or Western Maryland or Southern Maryland, there's a lack of resources, and it requires a lot of creative planning on the part of the child's social worker through the DSS system in that area.
I'd just like to add to that, just taking up on a couple of things that were discussed, that starting early is so important because the variability of the resources that are available to support whatever is the most ideal process varies from jurisdiction to jurisdiction, and it varies from child to child. When we were talking about bouncing from foster home to foster home, I was thinking of a case in which a child that became a young adult was a patient in our clinic off and on for a long time, and it was really a combination of his therapist that went to visit him when he was sent into a nursing care situation and advocated for some of his rights there, because he was really not sure how to do that. So, while they were not really his official foster family at any point, they had become more of a clinic family. And so I think in those situations, it's important to recognize that we all have a hand in that, and maybe try to say that it does really, truly take a village.
Hi, this is a little bit of a different question, I think, and maybe more directed towards you, Maureen. Could you talk a little bit about the rights of the guardian? So for me, I work with some lower functioning individuals who may be nonverbal or more intellectually impaired, and living in group homes where parents have been designated as the guardian, and there's this concern about providers perhaps saying, well, they're an adult, we can't restrict certain things, but for example, a client has diabetes and can't just eat whatever they want, and the group home saying we can't restrict what she can eat, is just an example, but what's the right of the guardian in that case? Or same with personal hygiene, a client who's engaged in resistant behaviors related to showering, and the parent saying, well, there are certain things I would like my child to have met for their personal hygiene needs.
So the guardian has the right to make those decisions. And again, this is why it's so restrictive, right? So the guardian may be living in Baltimore County, and the adult person with a disability is in a group home in Cecil County and may only see the adult once a month. And the adult is giving these very specific requests to the group home staff, who may, have their own opinions about the adult with a disability and their capacity, and feel like, this person can articulate, I don't want to eat that, and we want to listen to them. But technically, under the law, with the exception of voting and some very specific civil rights, the guardian of the person can make those kinds of decisions, the kind of clothing they wear, the kind of diet that they have, the kind of medical services that they receive, is considered, an alternative you don't want to explore unless you absolutely have to. I should say, just as a caveat, it's not that the group of staff have any bad intentions, you know, and are thinking bad things about the parents or the legal guardian. It's often that this is a really complex area of the law, and even folks in this room that may be handling these kinds of situations on a daily basis may find it really confusing and may not really quite understand the nuances. I should say there is a really great resource that's available in Maryland, and I think it's going to go out in a future mailing. It's the Adult Guardianship and Less Restrictive Alternatives Handbook that is developed through the University of Maryland School of Law and Ellen Caligari, who's an attorney in private practice in Baltimore and Montgomery counties. And it's a great resource. We have a PDF file that we can share. So I'd strongly encourage you to give families access to that document so they can sort of go through some of these issues. In addition, the Maryland Developmental Disabilities Council on their website has a great resource that's called the Planning Now Guide that you can access, a PDF in English or Spanish, which really helps families sort of go through all the aspects that we're covering today on the panel. So the family perspective, the community perspective, the school perspective, the financial, medical, et cetera.
And actually, that's a really good lead-in. I just want to acknowledge that it's getting close to 1, so we're happy to take more questions, but if people are needing to leave. I emailed Pete a list of websites that includes the one Maureen just referenced, which are you going to send that with the follow-up email? That would be awesome. I didn't want to put it up here because it literally, you wouldn't be able to see it. It was like in 2-point font or something. But there's just a list of websites. Some of them are Maryland, specific, they're local, and some of them that are national organizations that provide support to families in transition. I did check and all the links worked as of yesterday, but that'll come out in the follow-up email for exactly the kind of thing that Maureen was just talking about. And I saw another hand.
I just want to add, there's another resource regarding God transition. It's for teenagers and for parents, and it's through the Maryland Department of Health. I think that's their new name now. And it's in Spanish and English, and it's a great program that you can download. And there are things that I'm trying to get the school districts now, especially for children that are on IEPs, about the health component of it, because I think that's always the least thing that parents do think about, because there's so many other things that they have to think about. And it's about just what schools can do to help with the transitions. But it is a wonderful resource it's a national thing, and they've adopted some of the programs here in Maryland. So, and I think there's going to be more push coming in. That's something also that physicians can make as part of their transition plan.
Thank you. And right here in front.
Could you give us the outcome of the case, the original case?
So the patient continued the medications and he had capacity. We did work through the therapy and myself with him, his reasons for not involving parents, and we met somewhere in the middle that he was able to not have them in the sessions, but able to share information with them. That's where we are at, fortunately, so far.
Thank you. All right, well, thank you guys very much.